It's wonderful to be here. Now, as you noticed, I'm moderating tonight. I haven't moderated these programs in the past, and someone asked me, Rabbi, what inspired you to moderate? Well, first of all the moderators are busy tonight because there's a debate. But I said, I thought about it. I said, if I do a great job, so everyone will be impressed, everyone will be happy. And if for whatever reason I offend everyone in the room, then I could always run for president. But this is a reflective time of year. We stand here a week before Rosh Hashanah, the Jewish New Year, a time of reflection, a time of introspection. I'm not going to give any sermons tonight. We'll save that for next week. You know, they say a story. There was a rabbi that had a dream that he was giving a big sermon, and he woke up and he actually was. But this topic, as Barry had mentioned, is a topic we all need to think about. It's a topic that's on all of our minds, law, medicine, and the right to decide. And I'm honored to have the panel that we have. Professor Sharona Hoffman from Case Western Reserve University is both a professor of law and a bioethicist. Dr. Ken Prager from Columbia University Medical School is a renowned bioethicist and medical scholar. And Rabbi Professor Michael Broyd, who is a professor of law at Emory University Law School, in addition to a rabbinic scholar and author of numerous articles. So I think the program tonight, the discussion tonight, could not have a better topic and panel to them. Now, I just want to mention, as we begin our discussion, you know, when I was a young rabbinical student, 14, 15, 16 years old, so what do rabbinical students do for fun? So Rosh Hashanah, in the afternoon, we'd take a hike. We'd walk 2, 3, 4, 5 miles to a local hospital. We were 14, 15 years old. We'd walk into the front desk and say, hi, my name is Shalom. I'm a rabbinical student, and I'm here to blow the shofar and visit the Jewish patients here at the hospital. And the reaction would always be the same. They'd say, well, hold on 1 second. Let us get you the list. And 5 minutes later, the 2 15-year-old little yeshiva students with their black hats would be going room to room, visiting the Jewish patients who were most appreciative, for the most part, of us visiting and hearing the shofar. And it was all nice and good. Today, obviously, you can't do that. Today, you have HIPAA laws. Today, you can't walk into a hospital, nursing home, any place, and say, I'd like the list of patients by religious denomination. They're not going to give it to you. So the element of privacy is something that's at the forefront of our lives today. People want to have privacy. One of the issues, and throughout this debate season, and it's been a little crazy, is the issue of privacy, releasing medical records, releasing tax records, and what parts of our lives can and should remain private. Now, when it comes to the field of law, obviously you have attorney-client privilege, which is a very important bedrock in the legal system. In the medical world, we have doctor-patient confidentiality, which is also a very important thing for all of us to have as patients, to know that we could speak to our doctors in privacy. And in the rabbinic world, it's no different. There's a certain clergy privilege one can have when speaking to a member of the clergy, knowing that they're not going to then go to the news networks and broadcast whatever you just told your clergy person in confidence. So to begin our discussion about confidentiality, in the past we've always shown a film clip. So there's a film clip that shows the ultimate bad example. Barry spoke about some bad examples of eating and living lives that may not be all that healthy. The worst example possible of breaching attorney-client privilege and the ultimate disservice one can do to their client, by the legendary legal scholar Al Pacino.
And ladies and gentlemen of the jury, the prosecution is not going to get that man today. No. Because I'm going to get him. My client, the Honorable Henry T. Fleming, should go right to jail. The son of a is guilty. That man is guilty. That man there. That man is a slime. He is a slime. If he's allowed to go free, then something really wrong is going on.
Mr. Kirkland, you are out of order.
You're out of order. You're out of order. The whole trial is out of order. They're out of order. That man, that crazy, depraved man.
Please.
guys. Let's make a deal. Let's make a deal. Hey, Frank, you want to make a deal? I got an insane judge who likes to beat a lot of women. What do you want to give me, Frank? 3 weeks probation?
Damn it, hear what I said?
You son of... You're supposed to stand for something. You're supposed to protect people, but instead you murder them.
Shut him up!
You killed McCullough. You killed him. Hold it. Hold it. I just completed my opening statement.
Obviously not the best example of attorney-client privilege. But the issue and the case I'd like to begin with and address to the panel this evening is as follows. Several months ago, I was speaking to an individual who had an elderly father. The mother had passed away. An elderly father was in poor condition, hadn't been to a doctor in many years, and was starting to slip mentally. And they finally did an intervention where all the kids came over and they said, listen, Dad, you gotta go to the doctor. You have to go to the doctor. And he agreed. And all the kids took the day off from work. They all went. They're sitting in the conference room. The doctor does his exam. The doctor comes in after the exam, turns to the children and says, I'm sorry, but my patient instructed me not to discuss his medical condition with you. Professor Hoffman, what's the legal stance? What are we meant to do when we maintain attorney-client privilege? Or in this case, doctor-patient confidentiality would be no different. If someone came in and said, I want to make a will, I want to disinherit, whatever's going on, and you feel that the competence is slipping, and the kids say, what's going on here? What do you do?
So the question of competence is a very sensitive one, and generally it's actually up to the doctor to determine if the patient is competent. If this doctor believes that the patient is competent, he absolutely has to respect the patient's wishes to not disclose the medical conditions to the children, and sometimes there are very good reasons why a parent might not want medical conditions discussed with children. Now, if the doctor determines that the patient is actually not competent, hopefully there is a durable power of attorney for healthcare, which is a document which names the decision maker that is going to make decisions when the patient loses decisional capacity. And then the doctor should talk to the decision maker. Now, some people say, well, all of my children should be my decision makers. That is not a good idea, because oftentimes the children will disagree.
Really?
So, yeah, can you believe it?
Children disagree. Wow.
So it's really important to have a durable power of attorney for healthcare and to name a particular decision maker. You should also name an alternate in case the original decision maker is unavailable. But the doctor cannot just discuss it with all of the children or anyone who came to the visit because of HIPAA confidentiality rules and because hopefully there is one person named as the decision maker.
But in a legal context, if someone came into you as an attorney, as a legal professor, and discusses a legal matter for their business, for their personal lives, for their assets, where you get the feeling that there's serious questions as to their competence. You're not a doctor, you're an attorney, you're a legal expert. And the kids come along and say, by the way, mom's been acting strange lately. Have they stopped by to see you? Is anything going on? What do you say?
You cannot disclose the conversations you've had with a client unless you discover that the client is about to commit a crime that is going to hurt another party. If the client says, I'm going to rob somebody, I'm going to kill somebody, whatever, then you disclose to the proper authorities. But you cannot just independently decide the client was not competent and go tell other people.
So, doctor, what do? Often it's not a question of a competency test. Often these people are competent enough to be able to pass, at least on good days, a competency test, but there's serious questions as to the mental health, physical health, taking care of this person, and the children want to be involved. You may know the family. Do you not discuss it? Do you break that attorney-client or doctor-patient confidentiality? What would you do?
Well, first of all, I agree with essentially all of what Professor Hoffman said. I would, first of all, want to explore with my patient, why don't you want your kids to know about this? I would like to know if there's a semblance of rationality into why the person was wishing to withhold this information. And if it were appropriate, I might point out how this might actually be harmful to this patient. If, for example, the patient were to lose capacity, and at that point decisions had to be made in the absence of any knowledge of the patient's medical illness and what's wrong, the family may be at a loss as to make appropriate suggestions or decisions as to how this patient should be treated. But I'd like to know if there is some semblance of rationality. And as Professor Hoffman said, I think if this patient passes the test, and by the way, sometimes it is not a black and white issue. The issue of capacity can be very subtle, it can be very nuanced, and doctors can disagree amongst themselves as to whether a patient has capacity or not. But if I am convinced that the patient has capacity, as Professor Hoffman said, that patient has the right to withhold this information from their children. I might say that this happens very infrequently. What happens much more frequently is when the children say, "Don't tell Dad that he has X, Y, or Z." And the dad has capacity, and the family wants to protect their loved one and say, "Don't tell them they have cancer," et cetera, et cetera.
And what would you do in that scenario?
What I would do in that scenario, again, is to investigate the circumstance. It's not one size fits all. If I have a patient who just came from China, speaks only Chinese, comes from a culture where the family and the elders were shielded from bad news, and when in fact there were very few options for treatment, I would respect the wishes of the family. If it was clear to me that the patient wanted to know what was wrong with them, I would explain to the family that patients have the right to this knowledge. However, I think that we have to understand that this is a multicultural area, as was pointed out by Mr. Ostrowski. You have people from all over the world, and we have to understand that in certain cultures, in certain places, it is the norm not to disclose bad information to people, and we have to respect that.
So, Rabbi, help us out over here. From the Jewish law perspective, what do you do when someone's clearly in distress? There are clearly steps you can take by informing other people that can help this person in the long run. Yet you're bound by attorney-client privilege, you're bound by doctor-patient confidentiality. Is there a greater good argument that can be made? When is that made? And what do we do here? Help us.
Well, let's step back and consider a more nuanced problem, which is a patient is still competent, but they're not really competent to do the job that they're still doing. I'll reflect on a story. Almost 30 years ago, I clerked for the late Leonard Garth, who died only a week ago at the age of 95, a Court of Appeals judge in New Jersey. About 10 years ago, Judge Garth reached out to me and said, he used to call me Rabbi Broid. It was so embarrassing. He used to tell me I should call him Leonard, which I could never do. I would always call him Judge. He said, "Rabbi Broid, I'm going to start sending you Court of Appeals opinions. If you think I start losing it, and I should stop hearing cases. Not I've become incompetent, but just I should stop being a United States Court of Appeals judge. You should tell me. And if I don't listen to you, you should write a letter to the chief judge saying, you were asked to read all of my opinions and the man is slipping." I never wrote such a letter, but I did for many years read opinions from Judge Garth at his instruction, and it never dawned on me that he was slipping. And by the time he was ready to retire, he'd reached his own conclusions. To me, it seems clear that when a patient has become completely incompetent, Jewish law, of course, recognizes, as does American law, that they're no longer competent. But a harder question is, what do you do with an elderly patient who's completely competent but needs to stop driving? Not needs to stop thinking, not needs a guardian, but needs to stop driving.
Professor Hoffman has a whole section in her book about driving and encouraging elderly parents or others to give up the keys at the right time.
At some point, the Jewish tradition recognizes that there's a greater good in compelling people who are generally legally competent to stop engaging in activity that's reckless, particularly when this activity is dangerous to others, but even merely when it's just dangerous to themselves. You don't have to be incompetent in totality. You can be incompetent in parts. And when you become incompetent at driving, somebody needs to intervene to take away the car keys. When you become incompetent to take the subway, somebody needs to make sure that you don't get on the subway every day. It's important to understand that the Jewish tradition not only recognizes incompetence in the whole, a person can be incompetent in totality, but there's a call to intervene when a patient who's generally competent is engaging in activity that they're not competent to do, that's harmful to themselves or harmful to others, driving, many other life activities people lose their ability to do. And in those situations, the Jewish tradition does recognize the greater good associated with alerting the authorities. And sometimes the authorities are the family. Sometimes the authorities are the family to say, excuse me, you need to make sure that your mother or father stops driving.
Professor, is there such a distinction in civil law of competent in part?
No. You're either competent or you're not, according to the law.
Okay, so let's move on to an.
Can I
Sure,
just say
sure,
one
jump
thing?
in.
In medicine, there is a notion of having
Tell us.
capacity for some things and not others. The more complicated, I don't know if that's legal or not, but that's what we do. A patient, for example.
We'll have a lot of answers to that question later, right?
Well, just so you know, if a patient, for example, may lack capacity to make a nuanced and judgment about something very complicated like chemotherapy or some very difficult and complex operation. On the other hand, asking the patient, who would you like to represent you if you become too ill to make decisions? Who do you trust? We feel that a patient very often will have that capacity, but not for something more nuanced. So we do make distinctions.
So moving on from a scenario where a person was possibly at risk to themselves to a scenario where a client may be at risk to others. Someone walks into your door, you do trust in estates, and he says, I need to write a will. You've been representing our family, my wife's family. You've been our family attorney for many years. I need to write a will, and I need to do it now. And you say, why all of a sudden? I've been pushing you for 20 years to write a will. They say, well, I just found out that I have a communicable disease, and I'm very concerned about it. And you say, well, did you speak about it with your spouse? And you say, no way. I'm not speaking about it with my spouse. They're going to want to know where I picked it up. What do you do then? When you have attorney-client privilege and your client is possibly putting another client of yours, a fellow member of their family, at risk, do you break that confidentiality or not? We're up in the ante a little bit here.
Yes, I'm earning my dinner here. So I think I mentioned this earlier. You may break the confidentiality mandate if you find out that your client is about to commit a crime that will hurt another. So in your scenario, it actually depends on state law. And I think most states, I'm pretty sure New Jersey is one of them, make it illegal for the attorney to maintain confidentiality if a client has HIV and the attorney knows that the client is going to infect somebody else. That is a crime, and so you have to inform proper authorities.
We actually have an article about that at the back of this booklet about HIV confidentiality. But what if it's not HIV? What if it's something more?
Herpes, let's say.
Okay, perfect.
It depends again on state law. Under some state laws, it's a
in Cleveland,
crime.
in Ohio, what would you do?
Yeah. You see, that's why I don't practice. I just preach. It depends on state law. If state law says that it's a crime to endanger somebody else with a regular or a non-HIV STD, then the attorney has to inform. If it's not a crime to infect somebody with herpes, let's say, then you have to maintain confidentiality. Confidentiality is a very high priority value.
And you would look your client in the eye 6 months later who says, you knew that my spouse had this and you didn't tell me.
Oh, they're both my client all of a sudden?
That was the case. You're representing the family here.
Yeah, I would have to explain that, you wouldn't want me telling your spouse the secrets you tell me, and so vice versa, I was following professional ethics.
Dr. Prager, you founded the bioethics panel at Columbia University. This case comes to the bioethics panel. What do you do?
This case would not come to the bioethics panel because the law is very specific, as Professor Hoffman said. Okay. In New York State, and I'm sure in New Jersey as well, there are a list of communicable diseases which you have to report to the public health authorities. And in the case of HIV, for example, which is obviously a lethal disease if untreated, you must, by law, report this to the authorities, and then you tell your client, you give them the option of notifying their contact or contacts, and you have to be convinced that the contacts have been told. If you are not convinced, you tell them, by law, I must report this to the healthcare authorities, and they will contact your contact. What they say is, they don't say to the contact, your husband George has HIV. They say that we have been notified that one of your contacts has HIV, and we recommend that you take the appropriate steps. In something like herpes, I don't believe that that is a mandated law that has to be reported. I should tell you also that the law has changed, that HIV initially, because of political issues, was not treated like a communicable lethal disease, and because of pressures and because of wanting to protect patients with HIV because they were so scorned and made into a pariah, this legal reporting was not present at first when the epidemic began. But as people began to accept the fact that regular people can get HIV, it was not the type of pariah situation that it was before. It has now entered into the domain of a regular public health issue where the public health authorities take over.
Rabbi Broid, Talmud and the Jewish legal system, and the Bible for that matter, consider causing bodily harm to another person to be a sin, to be a crime. Would passing along a non-life-threatening communicable disease fall into that category?
Yes.
And what can be done, what should be done about that?
I think that the Jewish tradition mandates that a person do everything that they reasonably can do to prevent the transmission of a serious disease from one person to an innocent partner. The Jewish tradition, I think, might even recognize a right to breach your legal confidences in that situation if you're prepared to suffer the penalty. It wouldn't mandate such a breach, but it might very well permit it. And I want to note that there's another option here, which is if both of them are your client, you can noisily withdraw from one of them. You could turn to the wife and say, I can't tell you why, but I represent somebody who's intimate with you. And this has created a conflict. This has created a conflict between my representing him and my representing you. I can't tell you more about what this conflict might be, but you need to hire your own attorney because I can no longer represent you because you are in conflict with another client of mine. And when the wife says, I don't understand, which would probably be my response as well, you are supposed to say, well, I can't explain to you more, but I'm sure if you find another attorney will help you figure out what could be the conflict.
This wouldn't be a case to bring in the children, to say, well, let's have, right.
But it's important to understand that the Jewish tradition mandates that the prohibition not to stand by while an innocent person's blood is shed is strong, and that it's really an ethical wrong to be aware of information that can protect somebody from significant harm and do nothing with this information, even when, let me add, even when the law of the jurisdiction requires this. Sometimes we suffer for our moral principles. Being disbarred, very painful activity, is not jail. And when you have a choice, perhaps, between losing your law license and saving the life of another person, maybe you have to suffer. Easy to say to a group of lawyers.
To take it one step further, and then we'll move on to the next part of our topic, would Jewish law feel the same way about possible harm? Someone comes into your office, or you just know somebody who's exhibiting forms of risky behavior. We mentioned driving. They shouldn't be driving. Or someone comes in and they say, I frequently black out when I'm driving. And you say, well, why don't you give up your license? And say, well, I need to pick up my grandkids from kindergarten. I mean, are there possibly risky behaviors? You know that someone, a client, a patient, is sharing needles or just doing things that isn't causing a current risk to people around them, but has the possibility or the strong likelihood that it would. What would Jewish law say there? It's all questionable.
I think that possibility and strong likelihood are very different words. All of us engage sometimes in activity that poses the possibility of risk to another. I don't think you are under a duty to mitigate all risk down to zero. The strong likelihood of risk to another certainly rings the bell. I think even the reasonable possibility of risk to another. I frequently black out when I drive, not most of the times when I drive, but once a month. That strikes me as ample grounds to call the motor vehicle department to report this person, whereas I don't think I would do so for a person who had a single seizure that's for no apparent explanation. Risk comes in spectrums, and I don't think you have to maximize the spectrum all the time.
Professor Hoffman, risky behaviors. What's your take?
Well, to go back to the driving example, which thank you for mentioning, that's in my book. The book is described in the materials. There isn't a legal duty, and that's a big problem in the area of driving. Doctors can report it to state authorities, but in most states they're not required to. Family members are not required to in any state, and in fact, law enforcement officers often are not trained to identify at-risk drivers even when they have multiple car accidents. So there isn't a legal obligation in that area. It's really up to families to intervene and try to have those very, very difficult and emotional conversations with their loved ones. And we did that in my family, and it was not good. We made a lot of mistakes, which is why I wrote about it.